Welcome to this explainer. Look, if you're a law student right now, you already know that trying to memorize the vast, sprawling history of Hindu law, well, it can honestly feel like wandering through a giant maze without a map. There is just so much of it. That's exactly why we put this explainer together. It's designed specifically to give you the ultimate structured framework for mastering the sources of Hindu law for your exams. We're going to build your understanding from the ground up so you can walk into that test with absolute confidence. Let's get into it.
So let's start by diving into this exact question. It's a pretty fascinating paradox, right? How do ancient spell chants and thousands of years old historical traditions actually translate into the binding precedents that you'll be arguing in a modern courtroom today? Well, to really understand Hindu law, we have to trace this incredible evolution.
To do that, we use this thematic hierarchy to organize everything. Number 1, the ancient foundations. Number 2, digests and commentaries. 3, the power of custom. 4, tests of a valid custom. 5, British-era interventions. And finally, 6, modern sources and legislation.
Okay, Section 1, the ancient foundations.
Let's start at the very bottom of our legal pyramid with the absolute bedrock of the ancient Hindu system, our very first primary source, the Vedas, which are also known as Shruti. Now, Shruti literally translates to that which is heard. The Vedas are broken down into 4 main texts. You've got the Rig Veda, which is a massive collection of hymns, then the Yajur Veda, focusing on sacrificial rites, the Sama Veda, made up of chants, and finally, the Atharva Veda, containing spells, charms, and incantations. Now, you might be wondering, why does this matter for a law exam? Well, because embedded right within these ancient religious texts are the earliest legal principles dealing with foundational concepts you study today. Things like marriage, adoption, partition, inheritance, and Sridhana, which is women's property.
Moving right along to the Smrithis. Smriti literally means that which is remembered. The Smrithis basically took the foundations laid by the Vedas and expanded on them. And we can trace a super clear chronological timeline of how these ancient rules were set up. Starting around 800 BC to 200 BC, we see the early Dharma Sutras, which were mostly written in prose. As time went on, these evolved into the much more structured Smrithis, which neatly categorized human actions into 3 distinct rules. You have Achara, meaning rituals or daily conduct, Vyavahara, which is jurisprudence or civil law, and Prayashchitta, which deals with penance and expiation.
Now, what's really interesting here is the stark contrast between the 2 most prominent Smritis. On one hand, you have the Manu Smriti. Dating all the way back to 200 BC, it's the oldest Smriti and it is just massive. It contains 2,694 slokas, or verses. But contrast that with the Yajnavalkya Smriti from the 2nd century AD. It's way more concise, clocking in at 1,010 slokas. But more importantly, the Yajnavalkya functions much more like a pragmatic, secular law code. It dives deep into practical stuff like court procedures, ordeals, debts, pledges, partnership disputes, theft, and adultery. It marks a very clear shift from purely religious guidelines to actual, actionable legal procedure.
Which brings us to Section 2, digests and commentaries.
So as the centuries passed, reading the original Smrithis became increasingly difficult and, frankly, just a lot less practical. The law had to adapt. Between 700 AD and 1700 AD, scholars started writing regional interpretations and digests. Rather than reading the Yajnavalkya Smriti directly, a judge or a scholar would read a commentary on it instead. The absolute most famous of these is Vigneshvara's Mitakshara, which was a commentary written specifically on the Yajnavalkya. Another major digest you need to know is Jimutavahana's Dayabhaga. So the crucial takeaway here is that these regional texts essentially became the primary lenses through which ancient law was actually applied across different geographic regions of India.
All right, Section 3, the power of custom.
While texts and commentaries are super important, they aren't the whole story. The rigidity of ancient texts eventually gave way to the lived realities of everyday people through customs. These customs are highly adaptable and fall into 3 distinct categories. First up, local customs, which are tied to geography. For example, in the Ramnath case, a local custom allowed a marriage to a maternal uncle's or a paternal aunt's daughter, and that actually overrode stricter textual prohibitions. Second, we have family customs. Think of impartibility and devolution by primogeniture, where only the eldest son inherits, which governs specific Zamadar families. And third, caste customs. A classic example for your exams. Brahmins required a specific homam or fire ritual for a valid adoption, whereas for Sudras, the mere giving and taking of the boy was legally sufficient based purely on their custom. To really grasp the true legal weight of custom, you absolutely must know the Collector of Medora versus Muthuramalinga case. It's a landmark dispute where the court held that a widow could indeed adopt a child even without her deceased husband's explicit permission. Why? Because a recognized custom allowed the husband's sapindas, his close relatives, to grant that permission instead. This brilliantly illustrates a core principle in Hindu law. Clear proof of custom will outweigh written ancient texts.
Moving to Section 4, Tests of a Valid Custom.
Now, a judge isn't just going to blindly accept any practice someone claims is a custom. It has to survive a strict legal gauntlet. You definitely want to memorize this framework, as these are the exact steps required to prove a custom in a courtroom. To be valid, it has to check these 4 boxes. Step 1, antiquity. It must be long-standing, ancient, and invariable. Step 2, certainty. The practice cannot be vague or ambiguous in any way. Step 3, reasonableness. It has to be sensible, genuine, and impartial. And Step 4, it absolutely cannot be against public policy or existing law.
Let's see this framework in action. Take the Ramalakshmi versus Sivanatha case. The dispute here was all about inheritance. Does only the eldest son inherit, or is it the eldest wife's son? One party claimed there was an ancient custom of only the eldest son, but the evidence they brought to court was incredibly conflicting. Because of that, the custom failed the certainty test. So remember, if the evidence isn't totally uniform, the custom simply won't stand up in court.
Now, regarding the reasonableness test, look at the case of Raja Verma versus Ravi Verma. People were actually trying to sell the office of a temple trustee, claiming it was a customary practice. Well, the Privy Council stepped in and struck it down immediately, stating the practice was entirely repugnant and therefore void. Simply put, a custom cannot violate basic moral principles or be inherently unreasonable. And hey, if you think these tests are just ancient history, think again. Courts are still testing ancient customs against modern realities today. Just look at the Surat Parsi Panchat Board versus Union of India case. During the COVID-19 pandemic, the traditional use of dokmas, or the Tower of Silence, was legally scrutinized to ensure this ancient religious custom didn't violate modern public policy and health mandates. The law is always engaged in this balancing act between the old and the new. It's also vital to note that customs aren't these eternal prisons. A family can actually choose to discontinue a custom. This was famously established in the case of Abraham versus Abraham, where it was held that a family's conversion to Christianity could end their old family customs at the option of the party. Now today, the Indian Succession Act largely dictates these scenarios, but the principle of discontinuance is still a crucial part of customary law history.
All right, Section 5, British Era Interventions.
Before we got to modern statutory laws, the British attempted to codify the sprawling, fluid legal landscape. During Warren Hastings' time, British colonial courts really struggled to understand the massive web of smritis, commentaries, and local customs. To fix this, a code of Hindu law was prepared by 10 learned pundits. This text, originally called the Vivada Arnava Setu, was later translated into what became known as Halhead's Gen 2 Code. This is a brilliant illustration of the first major institutional attempt to freeze these fluid regional customs into a single translatable document that British judges could actually apply.
And finally, Section 6, Modern Sources and Legislation. Let's step out of history and into the modern courtroom. What actually governs Hindu law today? Well, when the ancient texts and customs are completely silent on an issue, modern judges rely on the principles of justice, equity, and good conscience. Furthermore, we now rely heavily on precedent. The binding nature of previous judgments means courts aren't forced to re-examine the validity of a custom or a smriti verse over and over again. They just follow the higher court's ruling. And of course, the supreme modern source is legislation.
Which brings us to the key codifications. In the mid-1950s, the Indian legislature finally took those scattered texts, the regional commentaries, and the proven customs, and codified them into unified statutory laws. I'm talking about the Hindu Marriage Act of 1955, the Hindu Succession Act of 1956, and the Hindu Adoption and Maintenance Act of 1956. These are the modern binding statutes you'll spend most of your time studying in law school today.
This definitive shift basically acts like a giant funnel. We start with the nuanced, highly flexible historical practices and complex tests of reasonableness and pour them straight down into the strict, bulleted reality of modern legislative acts. The entire history of Hindu law is literally just that, a funnel pouring thousands of years of deep tradition into the organized statutes of 1955 and 1956.
But as we wrap up, and as you pack up your notes to go study for your exams, I want to leave you with a final thought to debate in class.
Have these modern statutes truly completely erased the ancient texts? Or when a judge relies on justice, equity, and good conscience today, do the ghosts of those 3,000-year-old customs still secretly steer the gavel? Thank you so much for joining me in this explainer. Best of luck in those exams, and we'll see you in the next one.